And
Um,
and I do know the ketchup is not the point, but it is so hard to ignore it.
and, and we're live. It is Wednesday, June 29th. It's my dad's 70th birthday.
Ooh,
So
happy
Ooh, happy
birthday.
happy
birthday.
birthday, Dad. And we are here with Kate Shaw of Cardozo Law School. And we are going to be joined shortly by Leah Litman of the University of Michigan Law School. And we are going to talk and what 2/3 of the power that makes strict scrutiny happen, the amazing podcast that you guys have. How long have you guys been how long have you been since you've gotten acquired and kind of like gotten picked up?
Well, so we've had the podcast. We may have a 3-year anniversary like this week. We sort of don't mark these things, but we're like exactly, I think, ish 3 years old. And then we've been part of the Crooked Media Network for about 6 months.
Oh, nice.
Yeah.
Perfect. Awesome. Some point you're going to have to tell me how you produce it so often and how you do it. How you're going to have to teach us your ways because
You
we
have
have
a daily show, Kate. What are you
but
talking about?
we're at the cost of like many years off our lives.
Us too, obviously.
Yes, okay. I'm like, okay, fair enough. But anyways, so I was going to start us off with the strict scrutiny TLDL, which is this new acronym I just made up that stands for too long didn't listen. That is basically like, if you haven't been listening to strict scrutiny, what would you say in like, a couple of minutes is like the things that you have been discussing both about the leak before Dobbs and then like how much changed between the leaked opinion and the actual opinion, and then just kind of like, I guess that'll lead us into the discussion of Dobbs itself.
Sure.
But go for it.
Sure. Okay, so people probably know that on Friday, the court officially released its opinion in Dobbs, both upholding a 15-week abortion ban in the state of Mississippi and more importantly, for purposes of the country and our constitutional law, overturned Roe and basically said that states could do whatever they wanted with respect to regulating abortion, that such regulations would be subject only to rational basis review. And thus, I think the majority opinion is best read to basically say states can prohibit abortion. And there's nothing in the majority opinion to suggest there's a constitutional requirement that states have exceptions for the health or even the life of the woman, although I presume those kind of as applied questions will be litigated. But overturning Roe and basically saying states can have at regulating and prohibiting abortion. And in just the 5 days since Dobbs came down, the numbers are changing so fast. I don't even want to venture a firm account of where we are in terms of the legal landscape, but it's something
Yeah.
like 13 states have, when all is said and done, and the trigger bans and also so trigger bans are laws specifically drafted to go into effect if Roe is overturned. So those are kind of recently drafted laws. And then there are states with like zombie laws that predate Roe that some states are arguing have sprung back into force with the overruling of Roe, although the laws themselves don't make reference to that eventuality. When all of that is sort of the dust has settled, it'll be something like 26 states will prohibit or substantially restrict abortion, but we are not quite all the way there yet. And there's litigation in a number of states about whether these zombie laws are even enforceable. So the ground is shifting really quickly. But that's basically where we are. Yeah, please.
Can I explain one thing to the audience? I
Sure,
saw
yeah.
a question in the chat. They asked, what is rational basis review?
Yeah, it's the most forgiving type of constitutional scrutiny. So states
Right.
pass laws and, municipalities, ordinances that regulate like every facet of our lives. And if a state is going to pass a law regarding how close to a fire hydrant you're allowed to park, or what time your liquor stores have to close, or kind of ordinary regulation of our commercial lives, you could argue that such a law is constitutional. It should be struck down, but most of those laws get what's called rational basis review. And if there's any justification that court could imagine or generate that would sustain that law, then the law gets upheld. So it's like an incredibly deferential and forgiving standard that ordinary legislation is subject to. But laws that draw lines between individuals on the basis of characteristics like sex, like race, laws that, either explicitly, laws that burden religious exercise, and
Things that
laws
are
that might
explicitly
burden a
in the
fundamental right. Well, that are
things that are
explicitly in the
explicitly in the
Constitution or
Constitution.
burden what's understood to be a right,
Yes.
even if not explicitly
An
in the
unenumerated
Constitution.
right. Yes.
Yeah.
Yeah.
Those get reviewed much more skeptically by courts typically. And, lawmakers have to work hard to justify a law that, say, burdens a fundamental right. So the court has said pretty clearly, regulating abortion, right, even prohibiting abortion, requiring individuals to remain pregnant and carry pregnancies to term, those kinds of laws are like liquor store closure laws, as opposed to laws about rights. And that is
No,
a
it's
pretty
100%.
radical proposition.
No, it's insanely radical. It's insanely radical. There's just so much. It's so dark. It's almost hard to kind of completely grok it. Right? Like I feel like it's been almost a week and I'm no closer to like feeling it in my bones. I'm just like kind of still in a little bit like angry mode.
Yeah.
I think that I've just been angry. I haven't even gotten sad. I think I was sad in 2016 because I knew that this was going to happen.
Yeah.
Oh,
yeah.
I mean, we all did. But like, I'm angry now.
Yeah.
Like ridiculously angry.
Yeah.
Like I've always been strident about the right to choose, and I'm just like more than strident now. Like I would say that I'm like aggressive. Like I just I don't see that changing. Like I feel like it's gonna be the rest of my life, unfortunately. But like, yeah. Anyway, what about the leak? Is there any? Not that I really actually give a shit about the leak anymore.
Yeah.
Except that it kind of does tie in to like just the erosion of the Supreme Court and its legitimacy in general. Like on the one hand, as you say, like the shocking nature of the Dobbs opinion, how blatant it is. Like I made a joke on Twitter that a lot of people like got in my replies and were like, actually, it's not actually overturned. And I was like, that is actually my point, in which I said, like, it took the court like a less time to overturn Roe versus Wade than it did Korematsu. And like Korematsu being the Japanese internment case, being one of the most pretty like widely regarded, like absolutely disgusting, like vestiges of Supreme Court jurisprudence, like has never been explicitly overruled. It came close in Hawaii v. Trump, which was a couple of years ago, but still not the same language that happened in Dobbs, which was like, in which they were like, we're just going to, like, Roe is hereby overturned. Like, they didn't even do that for Korematsu. Yeah. It blows my brain. Like, I'm just like, what? Like, yeah. So, anyway, so like, what about this kind of raw power grab and the fact that someone leaked this opinion?
Yeah. And the leak was in the very beginning of May. And you had asked, Kate, and I forgot to respond to this, about the difference between the leaked draft opinion and the opinion that we just saw in final form on Friday. And it is shockingly unchanged. I mean, it's pretty wild to have issued to have this draft leak. There's like some specific responses to the concurrence and the dissent. And like some, straight quotes changed to like curvy quotes. And that's kind of it. It's wild how it's an opinion that's really, really thin and sort of weakly reasoned in lots of places. Even I think people who support the bottom line result thought that when they saw the draft and thought, well, surely it's going to be workshopped and refined, especially in light of this, very public debate about it. Like if Alito cared, he could have refined it quite a lot and maybe strengthened some of the arguments that his critics were making against the draft. And he basically was like, don't care. It's perfect. I'll issue it. It's pretty wild.
Do you think that they did, like, the fact that it leaked made it so that they felt like they couldn't change
like it locked it in.
I think it locked it in, because what are they going to do?
Because they'd be very I can imagine him being self-conscious about the sort of scrutiny of the red line and looking like he was responding to critics. But like, I don't know, like editing is not shameful. Editing is a thing that we do after we write drafts of things. So I'm not sure why that being exposed would be a problem. But, but it was really shocking to me how unchanged it was for the most part and on the substance. And it is interesting to me how little the court, my sense is that the court is not really going to care or pursue the leak at this point. Like, I'm not sure how seriously they ever were. They, obviously the chief said that the marshal of the court was conducting an investigation, and then there was some reporting about requests for clerk cell phones. But we don't really know anything directly from the court about what that investigation consisted of. And I suspect they're going to finish this term. And this was an unbelievably both significant and like viciously acrimonious term in terms of what the court did and sort of what you see in the opinions. Like they're pretty angry at each other. I think it's obvious. And I expect they will just scatter. And the clerks will go on to their next jobs. And I highly doubt we will ever know who leaked the opinion. And I do wonder, I had assumed that it was a conservative, either a clerk, somebody sympathetic to the Alito opinion, whether in the immediate court circle or, somehow adjacent to it, that was responsible for the leak, and that the motivation was to lock in the majority because Roberts was clearly trying to peel off a fifth vote. And I think from his concurrence, that was obviously true. So he has a concurrence that says we could uphold this Mississippi law. We could let a state like Mississippi ban abortion after 15 weeks, but we don't need to confront the question of whether Roe is wrong and that there's no constitutional protection for abortion because, assuming without deciding that the Constitution does protect some right to access abortion, all a state needs to do is give people a reasonable opportunity to do that. And 15 weeks is a reasonable opportunity, and it syncs up with a lot of Europe. And so it's fine. That's basically what Roberts said. And it's pretty obvious to me that he was trying to get someone, and I presume Kavanaugh, to join him, which would have deprived Alito of his majority and at least, deferred for another term or two, the ultimate question about Roe's fate. And then I think he probably would have just joined the majority to overturn Roe, but it would have been, in this kind of gradual two-step as opposed to sort of this radical overruling in this first encounter that the newly constituted court has with the question. So I assumed it was a conservative clerk worried about that, or conservative, person worried about that, trying to head it off. And now I wonder, actually, I'm less sure if that, having seen this draft, I wonder whether someone on the other side of the court was so horrified by this draft that they thought the public needed to see it. Maybe
that's always
maybe to prepare
how I felt
for
about
it. Yeah.
That's always how I felt about
Did you?
it.
Well, I think, that
But
seems
I
more likely to me
actually-
now.
Yeah. But I don't know. Like I actually find I think that I find I think I find a conservative clerk or someone leaking this a much more convincing thing, because I think that having seen how little has changed, what I think happened is that there was, and this is like an interesting question also about transparency and legitimacy, which is that like having too much transparency, like the fact that we're not privy to the reasoning and the interior workings of these of judiciary en banc bodies like this, is actually like to the benefit of like a lot of a thoughtful kind of contemplation and everything else, and the editing process. And so I think that actually to your point, I actually think that seeing how little it changed made me think that like Roberts felt like to save the court, he couldn't keep horse trading on it or do anything else or do any type, that this, like if it came out differently, there would have been this exposure of right, and like that this is like.
But you think Roberts is? I mean, it's interesting. But you think, I think that Alito might have had that concern, but I'm not sure Alito cares much about the legit. I mean, I think that he just thinks that he's kind of a maximalist about that sort of imposition of his really austere vision of constitutional rights and constitutional methodology, and I think that sort of cementing all of that, when you have the votes to do it, is more important than the legitimacy of the court. Roberts, I think, cares a lot about the legitimacy of the court, but I don't think the leak would have stopped Roberts from an effort to try to get another person to join him. I think he just failed. I don't think that they were receptive to the argument, and they decided to stick with Alito. There's my co-host. Hi, Leah.
Hey, Leah. Thanks for wearing your hold on. Thanks for wearing your t-shirt. Alicia's back.
Of course.
Oh no.
I guess it shows up in reverse on the screen.
No, it doesn't actually.
It's perfect.
It doesn't. Okay, it's just on my screen. It's okay.
I was trying to come up with a picture that wasn't just some random picture of from Kate and Leah and Melissa like recording, and so it's like I feel like this shirt channels all of it right now.
I followed your cue.
I know, whose vibes really? Leah, welcome back to the show. We are well into kind of conversation. We were discussing, I don't know if you could hear, we were discussing, like, Alicia has a great question, then I'll let GDF get in because I have dominated this so far because I'm just like chomping at the bit to discuss this with you guys.
Which question do you want?
I thought that
all of them.
Yes, exactly. I thought that they were all great, but there was it was the question about race and abortion, and then I think that it was your follow-up question was quite good.
Yeah, so I mean, this could be completely off base, and again, I'm the foreigner in the room. Mind boggled
Alicia's
in general
in Canada
about the American system and the weird things that happen. But know this, we have the same cold as you guys generally. What I was wondering was how much of the anti-abortion movement is actually tied to racism and xenophobia? Like, is there a movement? Is it tied to white supremacy? Is this like a bid to try to force white women to have more babies?
Well, they claim the opposite in the opinion, actually. They claim that those who support abortion are in fact seeking to basically like implement a campaign of racial genocide, because supporting abortion rights is really about trying to coerce Black women, or women of color in general, but Black women in particular, into having abortions rather than babies, and thereby to suppress non-white populations and political power. And so actually, this is a racial justice outcome. Now, this is me channeling, obviously, Justice Alito, but that's not the centerpiece of the opinion, but it is there. And it's a theory that Justice Thomas has pioneered and has, I think been quite influential. But there's like a, up is down sort of quality to that logic. And is it right that this is that actually, like, I think that anti-abortion advocates are not a monolith, right? So I think that there's actually like a range of motivations. But are there corners of it that would like white women in particular to have more babies and are concerned about demography and political power? Like, I am sure that the answer is yes.
Yeah, especially like during the move to criminalize abortion in the late 1800s and early 1900s, that was led by Dr. Horatio Storr. There's considerable evidence that at least some segments of that movement were concerned about, white women using abortion to control, size of their families, and that method of family planning was going to change the racial character of the country. So again, as Kate is saying, not all anti-abortion advocates are a monolith, but at least at the time of the trend toward criminalization in the late 1800s and early 1900s, some segment of that movement was driven by concerns that abortion was being used by white women, and as a result, the color and character of the country would be changed, and wanted to restrict abortion on that basis.
It's also very unnerving for a couple of reasons, because there are so many children currently in foster care who really could be and should be adopted. For this energy, let's direct it there. And then secondarily, next term, I think there's a case that deals with the Indian Child Welfare Act that deals with governing the removal of out-of-home placement of American Indian children, and that somehow involves the Commerce Clause. I'm not really up to speed on that one, but it's hard to imagine that discussion of child removal will not, considering the court's lack of shyness about making very blanket decisions here, will come into play and probably have an effect on more than just the individuals in question.
There's also, just to really quickly like put a pin and then like add GDF, like I will totally let you go, but I will just say that Margaret Sanger and the birth control movement also has been accused of huge and has like huge ties to eugenics. There are and I will just say that there is a one of the interesting kind of more in the weeds procedurally kind of or historically parts of things that have been left to the states to regulate are things like segregation, which was explicitly taken out of the state's power. So like this doesn't like the backwardsness of this is quite profound in that direction. So I mean, so I'll just like add that little piece to it. But GDF, go for it.
Voting rights, gerrymandering, all the things the states do so well. However, I just have a question about why do you guys think there is such hostility to the Ninth Amendment? I generally have large Ninth Amendment energy when it comes to substantive rights. I feel like it's there for a purpose. I feel like you can't ignore that they specifically included not all the rights we wish to protect are enumerated here. So why are originalists just so angry with the Ninth Amendment that they choose to ignore it exists?
Oh no,
Kate,
Kate's muted.
I feel like you're on mute.
Her.
Yeah, she's muted.
No, I can't unmute her. She's and she
She
probably
has to
can't unmute
unmute.
herself. No, you have to refresh and come back in. It's like a bug. Yeah, sorry. Yeah, we're just stuck together
Oh,
with duct
weird.
tape.
I've never seen that happen.
Spit and duct tape over here. It's like holding us together. But
I always have big issues with crowds.
Yeah,
crowd,
crowdcast
whatever.
is not
Crowdcast.
perfect.
I wanted to make a snarky comment that it's because they want to make America misogynistic and racist again. Like, isn't it about bringing it back to like these rules that really are not socially acceptable anymore?
Well, that's up to the states, Alicia.
Yeah.
We're not saying anything.
Well, this is the other. I mean, this is how you ended up in a civil war, right? Like, you have states insisting on maintaining a structure of society that is, past, like, beyond passe and pretty cruel.
For me, it's also just the frustration is I do understand that there should be a slight hesitation to just like saying whatever you think is an unenumerated right that should add protection. But when it comes to things that have just like you can justify in a myriad of ways, or that just, I mean, maybe I'm just too much of a natural law like tendency that there are just goods that should be protected within the system and equality amongst the genders, even though the Supreme Court has said that this is an issue that affects only women and therefore is not discriminatory, which I still can't wrap my head around that. I apologize. This is just like venting at this point, but
yeah, Leah, what do you think about what are the rationale behind the Ninth Amendment kind of erasure?
I mean, a combination of things. One is that the kind of structural, or more like political theory concerns that the conservative legal movement identified with the court's substantive due process cases, are inconsistent with the very concept of the Ninth Amendment. The idea that there are some, I am by myself this week, so just getting some text messages.
No, it's fine.
Like inconsistent with the idea of, judicially enforceable unenumerated rights. And so it's not that different from like ignoring, pieces of the constitutional text, in the Second Amendment, like the well-regulated militia prefatory clause, or,
privileges and immunities,
right? Privileges and immunities clause, although Justice Thomas would bring that one back, or, some justices not inclined to enforce the right to effective assistance of counsel in the Sixth Amendment, or other kind of disfavored rights. But I think in addition to that, there is this theory that has been offered in the literature that the Ninth Amendment, even though it reaffirms the idea of non-enumerated rights, wasn't meant to be judicially enforceable specifically, so that perhaps the federal government and specifically the political branches or the states could recognize, non-enumerated rights, but that they wouldn't be judicially enforceable, given, again, some of the concerns that the court has identified with its substantive due process jurisprudence, concerns about judges doing freewheeling policymaking and, imposing their own preferences over the political branch.
So then if we, I apologize, Kate, I just have one quick follow-up. So
Kate just texted, she says her computer is restarting and I fear it will take a bit, so she's going to bail now.
Okay, sounds totally reasonable. Thanks for taking over. Good handoff.
If Congress can somehow gather the political will in order to pass laws protecting these, maybe it's too late for abortion. I don't know. I hope not. But if the other substantive rights that were listed, like birth, like contraception, gay marriage, and Congress passes per the 14th Amendment, Section 5, and they protect those rights and they get them in. At this point, though, it still doesn't seem to me that there would be a break or a concern of legitimacy or a concern of not a counter-majoritarian like agenda with the current composition of the court. Is that the wrong take? Should I be more positive about how much they'll defer to Congress in that way? Because at this point, the hostility towards agencies and the executive seems to be something that kind of gives me like a tint on the tea leaves, at least from my perspective. What do you guys think? I don't know.
I don't know, Leah. I mean, like, I think that there's, I mean, I don't, this is also like, I tweeted something out like in the wake of this about the Equal Rights Amendment, and a lot of people responded to me that like the Equal Rights Amendment would not be any type of panacea for this. And I get that. Like, I think that that's like possibly right. But like, Leah, I'd actually, to that point, like, not that we could ever, like, I think you know this, maybe you know this, but I did a ton of, I did a lot. I wrote my undergraduate history thesis on the Equal Rights Amendment and did interviews with Phyllis Schlafly and like Karen DeCrow and a lot of the leaders of now from that time. But I've spent a ton of time thinking about it. And I agree that it would not guarantee some right to abortion, but I do wonder, I do wonder about the value of it. If we had it, what do you think? Do you think that there's anything that can be done either in law or amendment to the Constitution?
I mean, sure. I don't think the Equal Rights Amendment, if it, the court recognized it as formally part of the Constitution, would have done much good before this court. And that's
right.
Because, the text of the ERA just prohibits discrimination on the basis of sex. The court has that passing paragraph in Dobbs that says abortion restrictions don't discriminate on the basis of sex because they single out people on the basis of pregnancy, and discrimination on the basis of pregnancy isn't discrimination on the basis of sex. And I think the court would say the same thing with respect to, discrimination under the ERA. Now, I think that a different court, might recognize that if and when, the country ratified the Equal Rights Amendment now, people recognize that discrimination on the basis of pregnancy is a form of discrimination on the basis of sex, given the
right.
interrelationships between, family care, sex roles, and discrimination on the basis of sex. But I don't think that, this court, even if the ERA was formally part of the Constitution, or this court recognized the ERA as formally part of the Constitution, would say an abortion ban violates the Equal Rights Amendment.
Do you think that so this actually brings me to also just kind of a fundamental question of like, how are you going to teach common law, Leah? Have you thought about this? I mean, like, I feel, I'm off teaching for the year, but yeah. So I'm like kind of like avoiding my existential crisis, but how do you feel about this and everything?
Yeah. So, obviously I will change some things in my syllabus. But the way, I teach constitutional law is kind of noting, historical trends, things change. So, like, the law isn't just one thing. And so, obviously my unit on substantive due process will look different. This year I taught affirmative action and race conscious remedies, but basically told the students, like, we are not focusing on the current status of all of the specific rules coming out of the court's cases, just because those rules are going to change, by next year, and by the time you graduate, by the time you take the bar exam. And so it's not worth your time to focus on the specifics. And so instead we just kind of focused on, the threshold big picture question about whether to subject race conscious remedies to the same type of judicial scrutiny as, laws like Jim Crow segregation. And so that's probably how I will teach other units that I feel like are more up in the air or unsettled. So in some ways it is helpful to underscore to students that law isn't just one thing, right? It's always changing, and people are always trying to change it, and understanding the ways in which it can be changed, right, is a skill that you are learning, and the arguments that you can make. But yeah, I mean, obviously it will be different.
I mean, I'm not trying, I'm also I'm just kind of trying to also appreciate what you have kind of in front of you, and what a hard time it is. I don't know, we have a bunch of questions because we're having trouble bringing people on screen. I'm just going to read a bunch of them. They're excellent. Well, the first question is from Daniel, and he asks, why was Alito but not Barrett or someone else assigned to the opinion? And his second question is, do you think that the conservative majority is batshit crazy enough to severely limit access to contraception? After all, there's no history or tradition of using Plan B or birth control pills in the founding era. And so this is kind of how far will originalism go? And yeah, anyways, I know you guys have thought a lot about this, and Melissa in particular has like written extensively about this, but what are your thoughts, Leah?
Yeah, so two things on that. One is that I don't think Justice Thomas, could have this majority opinion after he had the majority opinion in Brune, the New York guns case, from the sitting before. I think those two back-to-back opinions just would have been pretty difficult for, any justice, and just kind of like atypical from an assignment perspective. Like you don't give the two biggest cases to the same justice over an entire term. So that ruled out Justice Thomas. Obviously the Chief Justice wasn't with them. Justice Alito was the senior most remaining justice in the majority. It is possible, as I think both my co-hosts Kate and Melissa have speculated, that perhaps the opinion might have been offered to Justice Barrett, given that she was the only woman in the majority, but she's also the junior most justice. So hard to know exactly like how those things would have shaken out. And obviously Justice Kavanaugh felt compelled to write separately, whether that's because, he recognized the like ludicrousness of, being confirmed to replace Justice Kennedy and immediately overruling like one of the justice's most famous opinions, whether it's because, he represented to all of the senators that like he viewed Casey as like the most important precedent on precedent and like wasn't going to overrule it, or like whatever you think the reason is. And so, in that sense, maybe it's not that surprising. Although, again, to give this opinion to like the angriest justice on the court, who's just kind of like incapable of writing like more measured opinions that recognize like the difficulty of a question, was, a scene.
Yeah, it was such a scene. The tone of that is like, it's like egregious. Like, I mean, I don't know.
Yeah. A really naive question, not being a lawyer nor being American, but like, is there no mechanism by which like Supreme Court justices just deem themselves so unfit to be impartial and objective?
Yeah, it's called
or
recusal.
Truthful that they can be removed from the bench.
They either retire or they recuse themselves from a case, but it's all policed by themselves.
So
that's kind of frightening.
That's why we have whole confirmation hearings, and they're like they're really important. And like, yeah, this is why.
But those are also faulty. Like, Kavanaugh.
I know there's like a lot of, this is kind of a more fundamental question. So, but like it's just kind of your questions are like exposing existing fault lines in a really serious, but it's just kind of like, I don't know that those, I think that this term has certainly made those more apparent than others. So we asked Kate this question, but I'm super interested in your take too, Leah. Like, what do you think about like kind of the legitimacy of the court going forward after kind of this just very naked kind of power grab? I don't know, and the leak too. Just like, do you think that the confluence of those things, do you think the leak is just going to be forgotten and people will kind of like forget about it after a while? Like the extreme nature of Dobbs will kind of will prevail, but like, yeah, I'm just kind of curious what your thoughts are.
Yeah, legitimacy of the court is like big question, and it can mean many different things. I don't think the court is doing itself any favors, either in the decisions it is reaching, the reasoning in these decisions, how aggressive they are, just how they are kind of conducting themselves. And so like, but that is based on kind of like my assessment of their work product. And I think different people like assess what the court is doing in different ways. Having like read their opinions, I think it's like pretty astonishing how like ranging from sloppy to bad faith it is. Yes. So like one of the recent examples that's in like a slightly lower profile case is from like a big habeas death penalty case that I was following, Shin versus Martinez Ramirez. And in that opinion, Justice Thomas wrote for the majority, and he said, respondent, the defendant, does not concede or does not contest, that is, he concedes that he would lose, that is, he could not present evidence under the state's interpretation of the statute. But that's just incorrect. Like the defendant did not concede that. And most strikingly, like the defendant filed a motion to correct that statement in the opinion and ask the court to just say that they were assuming that for the sake of the Supreme Court's resolution of that question. And the state, the opposing party, agreed with them, consented to their request to modify the opinion, and the court just like rejected it without explanation. And so there's just this like very, like I just don't know where they are getting their facts from when they sit down to write an opinion. Like if it's all just like confirmation bias and like the story they tell themselves in their heads. But it's quite striking. So I think like the more you dig in, it is more concerning. And
it's also concerning in more high profile cases like Kennedy, like that is like I fielded a bunch of very smart questions from friends that are lawyers in Texas that are all kind of like, at what point did the Supreme Court's version of events get created? Because it is so different from the trial court's like version of events. Did it happen at like the circuit level? Like what happened in the briefing? And it appears that it happened in the circuit briefing, but like it's completely different than what was like. I mean, it's actually bizarre. Anyway, sorry, but like, it makes me actually feel a little bit. It makes me feel better to hear you say that out loud, Leah, because it is also my perception of kind of like how like the sloppiness. I don't know. I just like, I always heard the stories, and I'm sure you did too when you were clerking, that were about like the clerks going through the record and finding like basic mistakes, like basic procedural mistakes, jurisdictional mistakes, or like corrections, and that's part of your role, like without a doubt. And so I just don't, it's just like it's a weird red flag on top of everything else. Okay. Jacob has a great question. How much of a clusterfork do you think this decision is going to be federally, completely irrespective of the decision itself? For example, the issue where a procedure is capital murder in some states, but perfectly legal in others. Extradition problems for someone who flees from their state to get a procedure, even if they don't return to their home state, and interstate clashes when some states refuse to extradite. So I think this is around the criminalization of abortion procedures. So.
Yeah, I mean, I think it's going to create a bunch of problems, that the court and courts are going to have to sort through. One that's emerging immediately is, what does the court believe, is entailed within abortion? That is like, what is the right that is no longer protected by the Constitution? Because we've already seen some legislatures say, well, we believe certain forms of contraception or birth control are actually abortifacients, whether that's the morning after pill, IUDs, or things like that. And so like those issues are going to be sorted out, in the courts, and that's just going to be a disaster. Another issue that is going to be sorted out in different variations is, what are states' powers to restrict medication abortion, given that, the FDA has approved the use of mifepristone, including through like telemedicine and telehealth, to end pregnancies, up to a certain number of weeks, but states have restricted the use of mifepristone, before that point, sometimes through statutes that like explicitly or, single out mifepristone as a prohibited substance. So that's going to be another question, like whether and how states can restrict the use of FDA approved drugs. And then, there are those right to travel questions that could also come up. And if and when states try to impose penalties on out-of-state providers, out-of-state residents, then of course there will be questions about whether other states would extradite them as well.
Do you think that the drug restrictions will extend to other medicine that has nothing to do with abortion, but could inadvertently cause it or make it difficult for a woman to, say, get pregnant?
It probably depends like what exactly you're talking about. If states got wind of the fact that like some number of women, right, exactly, some number of women are using like a certain medicine as what states view as like a as a abortifacient, then like, sure, right, they could try to restrict that too.
So unverified tweet. I don't know who the original user is, but I know of the person who then commented on it. She is on, the person who retweeted it has new MS medication that she was asked extensively, which is fair, whether she was planning to get pregnant, because that's a common procedure for checking to make sure that nothing inadvertent happens, right? If a woman is on medication that could be detrimental. But then she was retweeting somebody who claimed that they can no longer get access to medication for extreme arthritis because of that, because she is of childbearing age, and the service provider will no longer give it. That's what, kind of wondering how far that'll go.
I saw that tweet as well, and I felt that was more the provider being afraid of litigation, and
the first tweet or the
rheumatoid arthritis tweet.
Interesting. Okay.
Yes, because of the tetragenic effects or whatever it was, and I think it came down to just afraid of litigation. But it is also very odd that to return an issue to the states is just going to create more questions that are going to require more judicial legislation, essentially, because then you have all these balls and strikes to call, but are not really ball or strikes because they're very substantive in nature.
Yeah. I mean, so I'm interested also, I think that this brings us to a follow-up question that Jacob had, which I thought was very good, which was kind of, and that I think, and Leah, you and I were texting about this, was about like the companies and the markets and like how much uncertainty this creates and how much the markets are going to hate this. I think both companies that are going to set up headquarters in certain states that don't allow abortion or access to abortion, where these types, like, and I mean, this also, and like the idea of, Jacob asked essentially, that certain states might make it so that OB-GYNs are uninsurable in certain areas.
Mm-hmm.
Now we're talking about drug manufacturers and what they decide to manufacture. I mean, like, how is this? I mean, it just seems like the administrability, like for no other reasons, Leah, like the administrability of this seems such nightmare. Like it just is like so insane and
a clusterfuck.
And clusterfuck. What do you, I mean, are you just kind of like, oh, we're just going to have to see how it plays out with all of this? Or do you have any kind of thoughts or things that you are willing to kind of hypothetical about?
I think it's insanity, right? Because like, if you're talking about employers that are in states that have criminalized abortion, there's nothing that is stopping, the state attorney general from subpoenaing company records, of companies that have promised to give their employees time off and pay for their travel expenses and abortion expenses if they need one. And so like, if this system requires people to inform their employers that they are going to get an abortion and to involve a bunch of people in abortions, then it seems like you are unnecessarily exposing a bunch of people to criminal or civil liability. And that itself is going to chill potential, conduct to like assist people or facilitate people in getting abortions. And so like all of these mechanisms, of support, to the extent they become like formalized and publicized, are just like, to my mind, like additional forms of monitoring, right? Like state monitoring, right? Where like the state can either formally subpoena records, as law enforcement officers, or they can rely on, the tattletale in the company who's like, like Jane took 3 days off and like, I think she was pregnant. And, so I don't think those are solutions.
No, I mean, they're not. They're like really crappy stopgaps. And it's, we have far less. I mean, it reminds me actually of like how what a terrible state, like it is like by no means the stakes of severity that this is, but like cannabis law is, and like the fact that like right now like the states are all like legislating cannabis and like this in like a different way, and the federal response is just non-enforcement, and that's like, it's such a weak protection. I mean, it's like, but anyways, but to your point, I think that's exactly right. So Dr. Doom asked an incredible question. We're going to close with this, but I'm interested in your thoughts on this. I have thoughts, but I don't know Justice Coney Barrett like anywhere near as well as you do, Leah. Probably not that you know her that well, but like you being the con law professor, do these laws effectively turn women into landlords who are prohibited from evicting an unwanted tenant? And the fact that the court, especially Justice Coney, believes the rights of the tenants are greater than the landlord because of the relative cost of each eviction. What happens to the millions of, I'm going to add quotes, people in cryogenic prisons through IVF, post IVF, like the embryo kind of question. So I'm curious what your thoughts are on that.
I mean, look, like there are real concerns about what this opinion is going to mean for individuals' ability to use IVF to have children. So, this opinion is cast in terms of, like concern for children, potential life. But the reality is that like the theory underlying it will make it harder for some people who really want to have children to have children. For those of you familiar with IVF, it involves embryo harvesting and embryo grading. Like literally doctors will go through fertilized embryos and give them grades. That embryo is a B or that one is a C, and they will make decisions about whether an embryo is even worth implanting. Sometimes IVF will require what's called selective reduction. That is literally another word for abortion. If more than, an ideal number of embryos implant, then, selective reduction or abortion is used to remove the less viable ones in order to increase odds of a safe and healthy pregnancy. So by its nature, IVF involves, the destruction of potential life, after fertilization, not necessarily after implantation, although yes, sometimes after implantation. So yes, like the theory underlying Dobbs could potentially call into question methods of assisted reproductive technology. And that's been one of the big concerns, about overruling Roe.
Yeah. I will take this moment. Thank you. I think that that's exactly right. And I would also just take this. Kendra Albert at Harvard is a clinical professor and has they have a great piece, Fear, Uncertainty, and Period Trackers, which Deirdre just put in the chat, and I'm going to put this out here. The AALS Law and Technology division, which is basically the law professors kind of professional organization, is going to be putting together a panel on this. Melissa Murray, co-host Leah Litman and Strict Scrutiny, is going to be there and talking about that, as is Nabia Saeed, who is the CEO of the Markup and has written extensively about kind of the privacy interactions, and so is Kendra Albert. We're not sure when that's going to be yet, but that will be coming up and hopefully open to the public and hopefully multi-streamed and published in a bunch of cases. But we're going to be talking explicitly about these issues. I hope that's Stevie, Leah.
Yeah, she's becoming needy.
The best. Oh, that's needy. Well, yes. Well, you're single momming. We'll leave you to it. Thank you for coming on. It was great. Thanks for wearing the shirts. Thanks for doing God's work on this stuff and doing all of, I know how busy you are, like right now, and just generally, and all, like Kate is and Melissa is, like, but like the education that you're providing, I really just do want to thank you. Like, it's so great and important. And yeah, I'm just really grateful for everything you've done and are doing. And and Thank you for doing it. Yeah.
Thank you very much.
Thank you for having me on. That's very kind. Always happy to be here.
Yeah. We will be back
Thank you.
On
Friday.
We have Tim Miller coming on to talk about his new book, Why We Did It, about flipping sides as a Republican and going to fight against Trump. And that will be 46 and something, 47 and something minutes from now. And until then, Genevieve?
We don't have fun anymore, but in lieu of fun, we have better vibes than the Supreme Court.
We like clearly have I mean, that's like a very low bar, but I will take it. Okay.
Hey, listen, I'm doing my best.